Okay, hi everyone. So I'm going to move over into a little bit more of a nuts and bolts discussion. Hopefully it will still be riveting. No promises. A couple comments to frame this discussion before I actually move into it. Fraud and abuse is an extremely complex area, very nuanced. We all practice in this area. There's never an easy question. There's certainly no way that I can impart to you all the nuances of fraud and abuse in 10 minutes. So I'm not going to try. This is really just going to be more of an issue spotting, Cliff Notes type discussion to help you spot the things you should be looking out for as risk areas. I actually think that this might be the world record for the shortest fraud and abuse presentation ever. I don't know that anyone has interest in tracking that, but I kind of think they should, because it's tough to boil it down. We are going to focus on a couple fraud and abuse laws for that reason. I'm going to talk about federal anti-kickback statute and also physician self-referral laws. There are others that we loop into this category, such as false claims. I'm not going to go there because I think those are, everyone understands how those apply to telemedicine services and others. Sometimes the questions that we get as a firm are with respect to kickback and self-referral laws. It's just less intuitive how those can apply in the telemedicine context. Let's talk about the federal anti-kickback statute. It makes it illegal to knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals or generate federal healthcare program business. A lot of legalese up there, but let me tell you that's a shortened version of what it really is. But in short, you can't knowingly pay cash in kind, something of value, in exchange for referrals. This is probably not the first time you all have heard about the kickback statute. It's in the news all the time. It's a criminal statute, something to take very seriously, big consequences. It's not just penalties. It's not just potential exclusion from Medicare. People can and do go to prison for this. Not everyone. I don't want to scare you, but it happens. Violations can happen if just one purpose is to induce referrals. So that means even if there are legitimate services being provided and there are other reasons for the agreement, if one purpose is for referrals, that's a violation. It is intent-based. The other thing that I will note before we get on to the telemedicine specifics, it's not just federal. States have their own counterparts for this. New York does. So you have David and Stacy here, fantastic New York lawyers, and I'm sure they'll tell you New York in particular is a pretty tough state, in my opinion. So I'm licensed in California. I do a lot of work there. We take some pride in a weird way that California is tough. I think New York might be tougher in some ways. All right, so how do we apply the anti-kickback statute to telemedicine? So I gave this some thought about how to relay this to you, and I thought about the questions that I get from clients, which are really, I think, the misconceptions that I hear. I wanted to do kind of a true-false slide with pop-ups or graphics. I'm not tech-savvy enough to do it, so I did it this way. And it's a little ironic that I'm presenting here, and I'm not tech-savvy, but hopefully this will still be fun. So misconception number one, this is something Jeremy and I have heard more than once from pretty sophisticated clients, in my opinion. So the statement is, well, I don't need to worry about anti-kickback because there are no referrals in telemedicine. So that's not true. That's a misconception. So I think a number of people think if you're a physician, and particularly if you're remote, even in another state, and you're providing telemedicine services to a hospital, your private practice, you are not referring your patients to the hospital, so how can there be a referral? The issue is that referral is a much broader concept. It's not just referrals, it's recommending, it's arranging. So an example would be if you order a test, if you have the patient admitted, that would be a referral. Even though you're 1 state away, 10 states away, this can still be triggered. The second misconception, I don't need to worry about anti-kickback because the telemedicine services that I provide are cash pay, or it's just for commercial payers, there's no Medicare, so I'm good, right? So maybe not is the answer. It really depends on state law. New York is tough, California is tough, Massachusetts is tough. You have to look at both. So even though you might have avoided the federal anti-kickback statute, states will often have a similar provision, and it'll apply to cash pay. It could apply to commercial payers. So just because it's cash only is not a free pass. So the bottom line with kickback is any arrangement for telemedicine services, you need to think about this, and you need to make sure the agreement is structured for compliance. that is a discussion in itself, but I think the two main things to think about is the compensation fair market value for the services that are being provided, and are those services clearly identified? How much, what's the time expectation? What are you expected to do in exchange for that compensation? All right, so now, so kickback was the easy one in some ways compared to physician self-referral laws. There are whole books just on this topic. I was joking with my colleagues here that there's really no way to boil this down to a 90-second discussion of what is Stark. So I'm not even going to try. A lot of this is legalese. We're going to go into a practical application to explain how it provides to a telemedicine arrangement. The only thing I'll note on this slide is, again, there are state counterparts, including New York. Okay, so I'm going to try and provide just a short, plain language description of what self-referral laws are, and we'll talk about it in the telemedicine concept. So essentially, Stark, which is the federal self-referral law, it limits physician referrals when there is a financial relationship with the entity. And this is not just ownership interest in the entity, it's a compensation arrangement. So it's a lease, it's a professional services agreement, it's a call coverage agreement. Any type of relationship with the entity to which you're referring could potentially implicate Stark. And I've listed 3 questions which are from the OIG. This is the analysis that you go through to determine whether Stark applies, and if it does, if you have a compliant structure. And I thought we'd walk through a pretty basic hypothetical in the telemedicine concept. So let's say there's a hospital which has a coverage agreement with a psychiatrist for patients who present at the ER with behavioral health issues. Not uncommon. We've worked on a lot of telepsych agreements because, frankly, there's such a shortage of psychiatrists. This is the only way that many hospitals can really make sure they have the care that they need for patients who present at the ER. So let's walk through the questions under Stark. Is there a referral from a physician for a designated health service? So the answer is yes. Designated health services are defined. They include things like lab, imaging. The big things that they include are inpatient and outpatient hospital services. So when you have a psychiatrist 10 states away who decides that admission is needed, you have a referral for designated health services. Next question, does the physician have a financial relationship with the entity? The answer would also be yes, because you have the call coverage agreement. There is payment being made. There could also be other financial relationships. There could be a PSA, there could be a lease, there could be a medical directorship. Well, not if they're remote, but there could be other agreements that also trigger this. So if you know that Stark applies from number 1 and number 2, you must fit into an exception. Very similar to high level to kickback, it'll be things like, is the payment fair market value? Are the services defined? Is the term 1 year? There's a long list of specific components that you need to meet. If you don't, it is strict liability. All right, I want to make sure there's time for David and Stacy, so I'm going to move things along here. I just want to mention briefly, and this is veering a little off course because it's not just fraud and abuse related, but we get a lot of questions about contracting with telehealth vendors. And this could come up in a couple ways. It could be a physician practice or a hospital that wants to expand the types of services that are available to their patients. They don't have the resources, they can't build their own telehealth system. And so they will contract with a third-party vendor that will also have support services. They may also have providers that help fill in, on off hours or weekends. Or it could be a situation where it's a physician on their downtime that contracts with one of all these startups. There's all this kind of Uber for doctors. Everyone's looking for the next big app where you can have direct to consumer. A patient clicks on a button and they get to talk to a doctor. Both of those can offer a lot of value. It keeps patients from going to the ER or urgent care when they don't need to. But there's also a lot of potential fraud and abuse risk. You need to look at those arrangements closely. I'll just say, lawyers, I don't want to talk badly about us, but we are expensive. I think we're worth it, but we are expensive. And so in my experience, sometimes a vendor, particularly a newer vendor, a more startup, they just have not had the resources to do the compliance that they need to do. And so you just need to be cautious when entering into agreements with those that you've really vetted it. I've listed some of the terms that I suggest thinking through and looking at closely. This is kind of a PSA. It's not fraud and abuse, but I will mention for business terms, because I just dealt with this with a client last week who had an agreement with a telehealth vendor. When you're looking at the contract, look at the termination terms. Make sure there is a way out. If you don't know this vendor well, if you have any questions about how reputable they are, you want to make sure you have an easy way out. All right, parting words. So the OIG has a great resource. I put the link up here. I don't know if you'll get the materials, but they have a lot of very helpful tutorials on fraud and abuse generally. And they also have these 5 tips listed. So I'm going to poll my attorney colleagues here. I'm going to ask you, which one do you think is the one statement that I want to impart to you all, if nothing else? And I'll give you a hint. It's kind of my pet peeve. You may have heard me complain about this. Yes, number 4. And that, 1, 2, 3, and 5 are so important, but I also think they're a little more obvious. We have probably all gotten calls from clients who said, but that company down the street is doing it, so why can't I? And it's tough because there definitely are companies out there and entities that are maybe not in compliance with the law and they're not getting in trouble. That doesn't mean that it's legal. And it doesn't mean that they're not going to get into trouble. Sometimes the government has limited resources and they're not going to start to pay attention until there's enough dollars there. And the more people that do it, the more that they might pay attention. So just be very cautious when looking at agreements and looking at partnering with other entities about whether this is really legal just because everyone else does it. And I have to say this, not just because we're lawyers, but consult with counsel if you ever have questions.